Hello. Okay, so we're going to do the judicial branch. Go over a few key concepts. I want to first start out with a definition. Okay, standing. So in order to present a case to a court, you have to have what is known as standing to bring your case before the court. Essentially, again, standing is the right to appear before the court. You're before the correct court, and that the court will hear your case, will listen to your case, will make a judgment on your case. If you do not have standing to present your case before a court, the court won't hear your case. In order to have standing, one, you must be before the right court. The court has to have the ability to look at your case and rule it. So if you're suing the federal government for some harm and you are in a state court, you don't have standing because you're in the wrong court. Because you would need to be in a federal court. Maybe a more obvious example, if you're trying to get out of a speeding ticket and you go before the family divorce court, you won't have standing because the family divorce court is not the court that handles your speeding ticket, right? Traffic court would handle your speeding ticket. So you need to have standing, number one. The second thing you need to have is a some type of direct harm done to you. The thing that you're suing has to have been done to you. So, or suing for has to have been done to you. This means I, for example, could not sue the state of North Dakota for not allowing gay marriage. I am not gay, not North Dakota. I have not applied for a marriage license in North Dakota. There hasn't been any harm done to me. I mean, you can say in a court of law sense, there has not been any harm done to me. You would have to be... I said North Dakota, right? Okay, I think I did. Anyway, I would have to be a gay person from North Dakota or who lives in North Dakota who's tried to apply for a marriage license. And then I would have to go before, the court and say, listen, I tried to do this. The court or the, state has denied it to me. That's caused a direct harm. Hear my case. Okay? So, one, you need to be before the right court. Two, you need to have some sort of more or less direct harm done to you. Then you need to have a third thing. Okay? The third thing is that harm that was done to you, if the court rules in your favor, there must be something the court can do to mitigate or remove that harm. So, if I... Okay, so EPA versus Massachusetts. That was a case where there was a lot of question on the issue of standing. So Massachusetts sued the EPA, the federal government, and specifically the EPA, for not enforcing the Clean Air Act with regards to greenhouse gas emissions. The EPA, or the Massachusetts, said, listen, Massachusetts will suffer harm because greenhouse gas emissions are going to cause rising sea levels, changing weather patterns, increased I think that area is increased severity of storms and increased rainfall, so increased flooding and things like that. It's going to cost a lot of money and it's going to be harmful. However, there was a lot of question. Like, Massachusetts, one is, do you have the right to sue the federal government? First of all. And are you suing in the right court? The court decided yes. The second question, Massachusetts, is a direct harm being done to you by this party, the EPA? That was something that people debated for a while. There's a gnat. That was fun. Was harm being done to Massachusetts? Yeah, but the question was, is this harm so indirect that the Massachusetts doesn't really have standing? So EPA doesn't regulate greenhouse gas emissions. Is EPA actually doing harm to Massachusetts, or is what the EPA could do to mitigate the harm to Massachusetts? If the EPA took certain action, are they the ones really doing? Is EPA really doing the harm to Massachusetts? Is it not everybody sort of doing the harm to Massachusetts by pumping out CO2 and just rising the sea levels? The court decided that Massachusetts had a direct harm done to it. So they were able to satisfy the second requirement to bring their court case against the EPA, because the court said the EPA is doing this harm. The third thing, and this is actually a really complicated matter, was if the court ruled in Massachusetts' favor, would Massachusetts be able to have the harm done to them, or that was being done to them, mitigated? So, if the EPA started regulating greenhouse gas emissions like Massachusetts wanted them to, would the EPA's actions somehow prevent or mitigate the harm Massachusetts was claiming would be or could be done to them? So, the Supreme Court had to wrestle with that. The lower courts did, and it actually became a Supreme Court case, and the Supreme Court had to wrestle with that question. They eventually decided, yes, even so far as global warming is a global issue with lots of actors, we cannot say that, or should not say that, the EPA should not be doing something just because there's all these other factors that are also going to cause harm to Massachusetts. EPA is, by not regulating greenhouse gases, is providing, a certain amount of harm to Massachusetts. It certainly isn't going to eliminate the threat to Massachusetts by global warming if EPA doesn't regulate, or if EPA does regulate greenhouse gases, but they can help mitigate that harm, can help, reduce some of that harm. So the court said, yes, if we rule in Massachusetts' favor and order the EPA to regulate greenhouse gas emissions, then Massachusetts will have some sort of relief. We'll be able to not have the harm done to them anymore, or as much harm, things like that. So, standing, one, you have to be before the right court. You have to have a right to bring the suit in that court. Two, you have to have had some type of harm done to you. Okay, and three, if the court rules in your favor, the court, by their ruling, by forcing somebody else to do something, that has to produce some sort of mitigating of harm or relief of harm. that's standing. Those are the three things that you should know. Right to bring the case before the court, have harm done to you, and the court can mitigate that harm. Okay. And what's the other big one? Standing. Jurisdiction. There are courts have both subject matter and geographic jurisdiction. So sorry, there really is a gnat flying around my face. Okay. So a court, a family divorce court has subject matter jurisdiction in family divorces and has geographic jurisdiction within Guilford County. So that court's jurisdiction is over family divorce matters and in Guilford County. Jurisdiction is the area of authority that the court has, what the court has authority over. Okay, that's what jurisdiction means. It's about who has authority and over what area. You can think of it like the police also. So the Greensboro Police Department does not have jurisdiction over Kansas City. A Greensboro police officer cannot go to Kansas City and arrest somebody. The Kansas City police have jurisdiction in that area, that geographic region, and they're the ones that have to make the arrest. Now, and the same thing applies with courts. If you've seen it in like the court cop dramas or whatever, where the FBI comes into like some town and people arguing about jurisdiction over a case or jurisdiction over, a criminal, and there's oftentimes it's a lot of a small town cop and is trying to find out some murder case, and the FBI comes in and says, we have jurisdiction over this area. We're going to find the killer, and the small town cop's like, oh darn, I have jurisdiction over this matter, and then the small town cop somehow wins and beats the FBI or something. That's jurisdiction. Okay. And like I said, jurisdiction involves both subject matter, an area of expertise for the court, and a geographic area, and the court's rulings apply to that geographic area. Okay, so another basic term that you need to know to understand the federal court system is the term of party or parties, not referring to a birthday party. A party is one of the sides in a court case. A party can be both the plaintiff and the defendant, if anybody's familiar with those terms. If you get sued by somebody, you are a party in a court case. In the Massachusetts v. EPA case, the parties in the case were Massachusetts and EPA. It's just a word to describe the people who are in the case, who are being sued, and the person doing the suing. So who can be a party? It's a person, a state. The U.S. government can be a party. U.S. government agencies can be a party. State agencies, and I think I said states already, can be parties. Nonprofit organizations can be parties. Businesses, corporations, any type of legal entity essentially can be a party in a case. And so those groups can all sue each other within certain limits. Necessarily have to worry about the limits too much. The important thing is to know that these suits happen. Okay. There are state level courts and there are federal level courts. Each state and federal courts have different levels to them. The state courts have a trial court, which is the first level of courts, the lowest court. You want to think of it that way. When you are sued, bring a complaint against the state. If you're in a murder case, something like that, you're probably starting at the state trial court. The state trial court, if you lose, you have the right to appeal. Your appeal will be heard by the state court of appeals. If you don't like the ruling the state court of appeals gives you, then you can appeal again to the state supreme court. The same thing goes for the federal courts. However, the federal courts begin U.S. district courts. There are 94 of those. 94 district courts. If you lose in a district court, or if you win, the opponent, in your case, could appeal. If they appeal, they're going to appeal to the U.S. Federal Appeals Courts. They're also known as circuit courts. There are 13 of those handling the various geographic regions of the United States, and one court for specific specialized cases. You can see a map that are on the PowerPoint slides, and it's also in your book. When you're at the appeals courts, if you lose, you can appeal to the Supreme Court. The Supreme Court may or may not take your case. If you back to state courts, when you appeal up, if your case is heard by the state Supreme Court, you can appeal then to the United States Supreme Court. However, the Supreme Court may not hear your case, and one of the reasons they may not hear your case is because they don't have jurisdiction in that area. They'll say, this is a state matter. We, the United States Supreme Court, do not have jurisdiction in this state matter, so the state Supreme Court opinion is, the one that's going to be in effect. So, the federal courts, which is kind of what we're most interested in because there's, one level of them instead of 50 different ones. The federal district courts are generally cases heard by one judge, so you go before a judge and you present your case, and the judge will issue a ruling one way or the other. If you lose, you can appeal to the U.S. Circuit Courts. Lots of times the circuit courts will generally have 3 judges ruling on your case. The judges could rule 2-1 or 3-0 in favor or against you. Essentially, the judges hear your case. They think about the issues you presented, relevant constitutional issues and legal statutes, and they issue a vote as to whether or not you're, have a case or not, if you're innocent or guilty, or if your suit is legitimate or not. Issue an opinion and a dissenting opinion. Most cases stop there, because after that you would appeal to the United States Supreme Court. There's tens of thousands of cases that enter the federal courts, and the Supreme Court only hears 80 to a little over 100 court cases every single year at most. So if you have 50,000 court cases and the Supreme Court's only maybe hearing 50 or 60 of them, very little chance that you'll appeal all the way up to the Supreme Court. For the Supreme Court to take your case, there's got to be something interesting about it. So, if you get it at the Supreme Court, though, you'll have, in the 99.99% of the cases, you'll have 9 justices hearing your case and ruling on your case. The makeup of the Supreme Court right now, we have Supreme Court's made up of 9 justices. You can see that on PowerPoint slide 9 with regards to the judicial branch. The important sort of thing to know for current political events is that we essentially have 4 more or less reliable conservative members of the courts, 4 more or less reliable liberal members of the courts, and then 1 justice, Anthony Kennedy, who is a conservative-leaning swing voter. A lot of if you're bringing your case before the court and there's a very sort of partisan or ideological breakdown to it, you're going to be targeting your arguments to Anthony Kennedy, more than likely, to try and get him to move over to your side, because you probably already have the 4 liberal members on one camp and the 4 conservative voters on the other camp. The Supreme Court justices, along with the other judges in the United States, have, at least at the federal level, have appointments for life. The reason why we provide lifetime appointments is that these appointments insulate the judges from needing to worry about the current politics of the time, needing to sort of pay tribute to political party or political candidates. Imagine, for example, Sonia Sotomayor was appointed by Obama. If she did not have a lifetime appointment, and she had to be reappointed by Obama, or if Obama could remove her at any point in time, or if, she had to be, her appointment would come up again, let's say in 10 years. And whoever's president in 10 years would have to decide on whether or not to keep her on the court. She could or might feel the pressure to adjust her rulings to make the person that's president happy. That makes sense. So if Bernie Sanders becomes president, he's the most liberal person in the Senate, self-described socialist at times, describes himself that way. He's from Vermont. If he becomes president, you could see Sonia Sotomayor and all the other members of the court who want to keep their jobs move very much to the left in their court decisions. If, they have to come up for reappointment. If Ted Cruz is president, one of the most, he's, a member of the Senate, but he hates the federal government. So he's a member of a body he doesn't really want to exist. It's a very, very radical conservative dude. All of a sudden he could put pressure on the court to make decisions that are favorable to him. However, by providing these lifetime appointments, it means the Supreme Court justices can say, we're going to make the ruling, we don't need to listen to politics, and this is, what we decide based upon our interpretation of the Constitution, our interpretations of the law, our internal beliefs and values, societal norms, and the arguments before us. They can, again, I say, be protected somewhat from the political whims of politicians. So that's why we have lifetime appointments, and that's important. Let's see, any other key important things? Remember Supreme Court decision, slide 11. We have this idea, that judges rule based upon constitutional and legal issues. It's important to note, though, that they're also, people are biased, so they're going to look at court issues on personal ideology, if they have Let's not say if they have morals, if they have specific, moral or religious upbringings that lead them to one decision or another. Like Clarence Thomas, one of the most conservative members of the court, the 14th Amendment is in the Constitution. It was voted on, it was ratified, etc. Clarence Thomas doesn't really feel like the 14th Amendment should exist. So he consistently makes rulings that kind of pretend that the 14th Amendment doesn't exist. I don't know. So that's the thing. It's fun. What courts do, this is, I guess, the final point. What courts do is they, or what we're interested in what they do, is they make rulings on the constitutionality of legislation. So the Affordable Care Act, Obamacare, came before the court. There were lots of questions that the Supreme Court looked at. One was the mandate that everybody have health insurance. Was that constitutional? 2 was the requirement that all states expand Medicaid. Constitutional? Were the regulations the federal government put in place constitutional? These state-based exchanges constitutional, etc. The Supreme Court ruled that the mandate as a mandate was not constitutional. The federal government could not require that people have health insurance in that sort of forcible way, in a way we might traditionally think of require. However, the Supreme Court ruled that the federal government had the power to tax people who did not have health insurance. The same way the federal government taxes gasoline. I think the federal government taxes cigarettes. Sure they do. They do tax specific people who do specific things as a way to encourage or discourage certain behaviors. We have the state and we have government heavily tax cigarettes in an effort, one, to help pay for the health issues that cigarettes cause people later in life that they may not be able to pay for. But 2, it's also what some people call a vice tax. Excuse me. The government taxes cigarettes highly to make it expensive to buy them, to try and discourage people from buying them, because if you make something expensive, it's going to mean that people can't have as much of it or won't buy as much of it, etc. If people are already smoking, if it's, if they're having to spend $4 a day on cigarettes, that's more incentive for them to quit than if they only have to spend $1 a day or whatever. So the Supreme Court said that the federal government could not require people to have health insurance. However, they could tax people who did not have health insurance. So they found constitutional the federal government's power to put, so this year somebody who goes a year without having health insurance will get a $95 fine, or 1% of their income will be fined, whatever is highest. So the court said that's a tax, not a punishment for not following the law type thing. The court found that the Medicaid expansion was unconstitutional. The federal government could not require states to expand Medicaid under the conditions, that Medicaid is currently in. So Medicaid has always been a voluntary program. What the federal government said was, you either expand Medicaid or we withdraw all Medicaid funding. So right now, the federal government is in North Carolina that hasn't expanded Medicaid is, let's say it's splitting the cost of Medicaid 50-50 with the state. So it costs, I'm making numbers up. Let's say it costs $4 billion a year to run Medicaid in North Carolina. The federal government spends $2 billion. The state spends $2 billion. The federal government said, under the ACA, you're going to expand Medicaid to 133% of the poverty line. And the federal government then said, we're going to cover all of that cost to expand Medicaid up to 133% of the poverty line. If you don't do that, though, we're going to take away all Medicaid funding, and you'll have to either not have a Medicaid program or pay for it yourself. The Supreme Court said that the federal government could not require that the states expand their Medicaid, with the punishment being taking away Medicaid funding. They said it was kind of like, it was coercive. It was putting a gun to the state's head and saying, expand Medicaid or you lose all this money. The states wouldn't have really had a choice in that matter, the Supreme Court said, so that was a violation of the Constitution of the state's power. And that's why we have a lot of states who have not expanded Medicaid. Excuse me. Some of these other things we're going to go over in the second half of the semester. There are a couple things we need to touch on, but fit really well in the second half of the semester. I guess one other thing, a majority opinion versus a dissenting opinion. When the Supreme Court rules on a case, so in the ACA I think it was 6-3 was the final decision. Or maybe it was 5-4. The majority opinion was written by somebody on the court. The majority opinion being the opinion of the 5 justices that agreed with upheld the constitutionality of the Affordable Care Act overall. The dissenting opinion is the opinion written by the 4 justices, or one of the 4 justices that did not agree with the 5 people in the court that made up the majority. That's the minority opinion. So you have a majority opinion and a minority opinion, or a opinion of the court also being the majority opinion, or the dissenting opinion being the people who lost the case, essentially. And the dissenting justices, the justices that did not agree with the majority of the court, get to write an opinion saying why they disagreed with the court in the matter. So that's roughly that. Hope that was fun.